Discrimination, unfortunately, it does exist, but here in the United States we have a variety of statutes and protections under the U.S. Constitution that endeavor to prevent discrimination. But what is discrimination? Well, let's take a look at this week's case. It involves basically a retirement community called a Country Place in Lakewood, New Jersey. And among the facilities that existed there was a pool. And the pool was available to all the residents at the facility, but the pool had very specific hours. And essentially the pool provided women could use the pool in the morning, men could use the pool in the afternoon after 5 p.m. Now, there were two couples that brought suit under the Fair Housing Act contending that that use of the pool was discrimination. They said it was discrimination because it did not allow people to use the pool whenever they wanted to use it, and it made a difference based upon no difference other than sex. That women could use it in the morning, men could use it after 5 p.m. They argued that is really pretty traditional kind of categorization of men and women. Women are generally considered as stay-at-home moms, at least in the old days, and men are the guys that go out and work. Therefore, men would be able to use the pool after 5 p.m. and women would use the pool in the mornings when they would be available. This, they said, is discrimination. Now, on the other side, the association argued, hang on a second. The reason we're doing this is because there are a number of Orthodox Jews who are members of the association, and they find that it is immodest for men and women to be swimming together. And therefore, we can't have both men and women swimming together, and that's why we have set up the hours, women in the morning, men in the evening. Okay, the case goes forward. Case goes forward to a federal district court, a trial court. The court hears the various arguments and comes away and says, we agree with you, association. We agree that this is not discriminatory and that the rules can be left in place since everybody essentially gets to use the pool, and so it really isn't any discrimination. Well, it went up to the Third District Court of Appeals, and on appeal, the court again heard this argument and came away saying, you know, you can't have rules that are based upon traditional characteristics of sex, that women will generally not be working and men generally are working, and therefore women use the pool in the morning, men use it in the evening. That is plain discrimination. And since it is discrimination, it's violative of the Fair Housing Act, and we find it unconstitutional. And in short, you can't have those kind of rules. Now, one important thing the court did comment on in a footnote was that it didn't address the issue of religious freedom. It did not address the issue of whether or not those individuals who were claiming that it was violative of their religious beliefs to have men and women swimming together was violating their rights. Court didn't comment on that, and the reason they didn't comment on it, other than to say we're not commenting on it, is because the argument wasn't raised at the trial court level. So, one important thing we learned from this case right off the bat is if you're going to make an argument, you got to make it right off the bat. You can't wait till you get up on appeal. If you wait till you get up on appeal and you haven't made the argument previously, you're playing out of luck. The other thing we learned here is that some activities that will generally not be considered as discriminatory in nature, such as basically making a difference as to the hours women can use a pool or men can use a pool, can in fact be viewed as a discriminatory and arbitrary determination. Okay, bringing cases every week so you understand how the law works. I'm David Allen.